We'll call us back to order. We're still in meeting number 25, and we are still televised, and we're in public, and we have a new guest. Mr. Corbett, it's great to have you here, and apologize for the lateness of the hour, but we've been working, seems like, around the clock on C23. You have an opening statement, I understand, so please go ahead and tell us your thoughts, and then we'll ask you some questions.
Thank you, Mr. Chairman. Mr. Côté has covered a lot of the ground, as you well know, in a very thorough way, and I'm hopeful that perhaps I can add some contextual information from my 6 years as Commissioner of Canada Elections, which ended in July of 2012. Before that, I was employed by the Department of Justice for 34 years, mainly in the criminal law branch, so I'm well familiar with the DPP and his organization. During my time as Commissioner, I was involved in 3 federal elections in a period of a little more than 4 years. You probably remember them all. I'm concerned for the ability of the Commissioner to investigate alleged violations of the Act in an effective and timely way. I'm a practically oriented person. There's nothing in the amendments that will enhance the ability of the Commissioner to investigate alleged violations of the Act, and there's one amendment that will detract from the ability of the Commissioner to investigate violations of the Act. One of the main problems with significant investigations is that they take too long. One investigation that we completed took 2 years and 1 month. The Director of Public Prosecutions spent 16 months reviewing what we had done. The prosecution brief was a few pages short of 400. It was a book, and this was a summary of the evidence that we had managed to put together. In this case, and in some others, delay is occasioned by key witnesses who declined to be interviewed by an investigator. In some cases, key witnesses were discouraged, actively discouraged from being interviewed by an investigator. What is missing from the amendments is the authority to seek a judicial order to require a vital witness to be examined by the investigator. This authority would avoid the need to use more complicated, expensive, and intrusive procedures, and might very well save considerable time. Again, I can't say a lot about cases before the court, but you can imagine what we had to go through when we had to sort out robocalls in general. The internet is unregulated. It's the Wild West. And the number of judicial orders we had to obtain and what we had to learn as we pushed our way through this quagmire was remarkable. Had we been able to compel witnesses, we might very well have advanced the case much more quickly. And I'm very concerned for the public perception of things when we can't advance these cases of considerable public interest. We already have an injunction power in the Act which allows us during the election period to go to a court for an injunction to get something done. We've never used it. We've waved it around from time to time, and people will know it's there and we can pursue it if we want. I expect that an authority to get a judicial order to compel someone to be interviewed might not have to be pursued all that often. Persons couldn't say to a witness, you don't have to cooperate, because the law would then provide a means to obtain cooperation. Its availability would frequently be sufficient, I would expect, to obtain cooperation from witnesses. What is detrimental in the amendments is the removal of the Commissioner's Office from Elections Canada to the Office of the Director of Public Prosecutions. Elections Canada is a vital centre of information and intelligence and expertise in federal electoral matters, and there isn't any other. The Director of Public Prosecutions certainly is not. What you would do with this is you would remove investigators from ready access to the experts at Elections Canada. the legal experts. These are people who are engaged in knowing this act and providing legal advice on it on a regular basis, including to investigations, keeping investigations in line, if you will. The auditors who apply the law to the financial aspects of campaigns, and the experts who run the election, who apply the laws to the actual vote and the campaigning and the election period. It's important to remember the Commissioner's Office is comprised of about 20 people, and they rely on resources where they can get them, and Elections Canada is the main source of that. Also, other police forces assist investigators. The DPP provides assistance to investigators in getting judicial orders and matters before the court. I'm not sure if the move would disturb the ability of investigators to get access to the records that are kept at Elections Canada. There are specific sections of the Act that guarantee access to certain records, but taking the investigators out of the organization may raise a problem for access to records. Records are vital to confirm complaints, referrals from auditors with regard to financial matters. That's a legal matter that I'm not able to give you an opinion on, but it's something to be concerned about.